like I said, there's more and more cases. They just stack up, and there's lots of awareness and lots of frustration, and the legal system and the powers that be are recognizing they have to acknowledge their wrongdoing faster when it is pointed out in a public and well-evidenced way. And again, that only empowers us because the awareness is there, the recognition is there. When we come to the table with saying something's wrong, people are not shocked. People are not surprised. People will look at the evidence, go, yeah, I believe it. And that's a far more powerful place than it was even 10 years ago. So things are looking better and better for that. Now, this is an issue that OPCA, that is the term that was created by Meads versus Meads, and it is a categorization of people who are filing documents into the court claiming freemen on the land and various other things. And that definition of OPCA here is organized pseudo-legal commercial arguments, OPCA. Now, make this a little larger. In Meads versus Meads, it was a divorce case, and in the process of the divorce case, the husband filed a whole bunch of paperwork that had all sorts of freeman, common law, whatever stuff on it, and the judge, in the process of ignoring it all, wrote a very long dissertation about everything this guy raised, taking apart everything and saying it's all useless, it's all garbage, it's all gobbledygook, and it's just frivolous and all that sort of good stuff. And it's interesting, there's something called orbita dicta, which is what a judge says, but it's not law. It's not a ruling. It's not official because it's only his opinion about something unrelated to the actual point that the case is decided on. So if a judge acquits somebody because of some technicality, but then he comments on the defense of that individual and says, well, this defense wouldn't have worked, and this defense wouldn't have worked, and this defense wouldn't have worked. Those are just commentary. Those are just opinions unrelated to the fact that they weren't a part of the discussion. Usually they say, I don't have to decide these issues because I've already decided this one, and so it's out of here, and but I'll still comment on these things. Again, that's just opinion. It's not law in any way whatsoever. And they keep on parading Meads versus Mead out as if it's law, as if some judge in the process of his decision making took into account this argument and took it apart and said, because of these facts and this situation related to my decision, this defense is no good. And he did that with each thing, instead of just being opinion about various miscellaneous things that were raised in the case. But as a result of this, somebody fairly recently, this was brought out in January 2nd, 2015, the Chief Justice, who is the head judge at the Queen's Bench level of Alberta, somebody had a motion of some sort. Oh, look at this, upon the court's own motion. So the Chief Justice took it upon himself to go, okay, we've had enough of these crazy documents coming in, and we're going to look at Meads versus Meads. Because it's not law, we're actually going to make an order related to the decision. Because in many cases, some people were smart enough to say, that's not law, forget it. Don't raise that crap, it's irrelevant. And it gets tossed out. But many times people didn't know. They treated it as if it was law because the person that was the defendant didn't know how to argue the fact that it was irrelevant. So they actually took it upon themselves at the highest Chief Justice level to issue a motion. It appears that there are from time to time attempts to file documents with the court that are in a form not known to the court and are or are intended to be an abuse of the court process. So you either actually are or you intend them to be. I don't think anybody's filing this stuff intending to be an abuse of the court process. They're actually trying to get their rights upheld, but the courts see it as an abuse because they have to take time to deal with it. And frivolous and vexatious, as discussed in Meads versus Meads. Okay, frivolous means it's unrelated to anything, it has nothing to do with anything, so it's just a waste of time. And vexatious is about being abusive in some way, Rather than just being a waste of time, it's actually harmful in some manner. And upon finding that the filing of such material may frustrate the litigation process and court management. Well, which litigation process? The lawful one or their fiction court process? Definitely their fiction court process. And court management. Which court? The fiction or the lawful one. And upon finding that the filing of such material may jeopardize the efficient administration of the court, which court? May result in significant delays and additional expenses, absolutely, and has deleterious effects that harm all or some parties involved. I'm not sure how there's any harm to any party for listening to a legal argument and deciding that it's irrelevant. So they're claiming some harm. I wonder what that harm is. And upon noting that documentary materials associated with frivolous and vexatious OPCA litigation strategies are uniquely associated with certain formal defects. Now, defects is a specific legal term with regards to paperwork. And formal defects takes it to a whole new level. And when you're putting in what your understanding of a particular position is, or your statement of what your understanding of what the law is, how can it be anything but your position versus a formal defect? And upon it appearing that the documentary materials sought to be filed have indicia associated with frivolous and vexatious OPCA litigation strategies as identified in Meads versus Meads, which means there's specific words, phrases, terms, ideas, concepts in the document that we can identify as part of the OCPA litigation strategies. And so they're going to talk specifically about what to do about it. Good for them. And just as a precursor to this, I agree with most of this because most people are not using the documents and positions properly. And so this, in effect, is largely guidance from the court, not only to the court staff, but to the individuals filing the paperwork. And you can look at this two ways. This can be a screw you to everybody from the court, or this can be, hey, if you're going to come to the court, do it properly. Don't waste your time with, some frivolous stuff, because some of it absolutely is frivolous, and I agree with that. So let's take what we can out of it that's positive. So it's hereby ordered. Now, anybody in Alberta, this is an order that covers all of the court registries and clerks in Alberta. The clerk shall review the documents proposed to be filed by any suspected OPCA litigant to determine if any formal defects appear as set out in List A. Formal defects. So we'll look at List A after we finish this page. If such documents contain any formal defect as set out in List A, the clerk shall refuse to file the documents with the court as option 1. Indicate on a copy of this master order the identified formal defects, which means they have to identify why specifically on the paperwork it's being rejected. Make a photocopy of and retain a copy of the master order with the identified formal defects and the first page of the document that contains the formal defect. So we have a record of what's been refused. Return the documents to the person attempting to file same and provide that person with a copy of the master order which indicates the identified formal defects. So again, this is a clear, concise, good process for the courts to take a position on. So you go in, you try and file your paperwork, the court clerk looks at it and goes, oh, you got this on here and you got this on here, so I can refuse it. And I'm showing specifically exactly what it is that's on here that I'm refusing it for. And then you have options. A person who seeks to file documents that were refused by the clerk may challenge that action. So you have a record of what's been refused and why. So you have something to challenge with. You have your evidence. A letter which states the documents requested to be filed were refused filing by the clerk pursuant to the master order for OPCA documents and a request that the action be challenged, the letter must include. This is a complaint process. The court is outlining a specific complaint process. You go in, you ask for some service, they refuse you the service, they tell you exactly specifically why, and because you got refused, you have the right to complain about it. Here's how you complain about it. A letter which states the documents were refused filing by the clerk pursuant and a request that action be challenged, the letter must include full legal name of the writer. Legal name is specific again. Mailing address for reply. They want to keep you within that jurisdiction probably, but then maybe there's a common law mailing address. the court file number, if a file number has been assigned, the court type of document refused, statement of claim, statement of defense, application affidavit, and the reasons why the document should be filed. So this is the complaint process that's covered by sue wrongdoers. And the Chief Justice is saying, hey, you got a problem because you've been refused. Now we have to officially notify you that you've been refused in writing and why it's been refused, and here's your way to complain about it. This is all good news. And by send along the refused documents and send along copy of the master order received, right, with the identified formal defects. So put your complaint together, provide the evidence, and send it in to us at the court center. A document refusal challenge response shall be made by the Chief Justice or his or her designate within 30 days, or such longer period as the court may direct. Response communication shall be made by ordinary mail to the indicated mailing address. Or you can just correct the formal defects and request the clerk file the documents absent such defects. So, sue wrongdoers, this is it right here. That's the process. This is how you complain. That's what they've provided for you. And again, every corporation, every legislation has a complaint process. They had a specific situation happening over and over. He's created and developed and issued a complaint process for you. So either go through the complaint or fix your defects and file it again. Now let's look at that Schedule A. What are the exact things that they are identifying as the defects? Prohibited OPCA formal defects. So now they've created this title. This is a title, the formal defects. These defects exist in many related variant forms and combinations. Variations in these prohibited formal defects are a basis to reject document filing. Circle any formal defect identified, litigant, title, and status. So there's something about the title of the person and their status, because people are making status claims. The litigant claims a specific title or status. These are the prohibited ones. A flesh and blood man, flesh and blood and bone man or living soul, freeman on land or freeman, free will, full liability person, sovereign man, sovereign citizen, or sovereign, or more. Okay, so I got a question for you. Do you see private person on that list of prohibited statuses? Do you see natural person on that prohibited list of statuses? No, because they cannot prohibit the actual status which you have that creates their office and gives them the power to exist in their office. So I find this, again, it's not just what they say, it's what they don't say that lends credibility to any particular position or understanding. So these things I've always had problems with, because most people don't understand them. In many cases, they're irrelevant to our particular legal system. And as I've taught for a long, long time, you're a man or a woman with the legal status of private person at common law. That's the only status that's recognized at common law of a man or a woman in their private capacity. And flesh and blood and man is not a status. It's what you are, but it doesn't indicate any legal status. So again, as far as I'm concerned, this is just some more confirmation and things to avoid. I wouldn't use them, and they've now said you can't, so that's great. So representation of names, -- format. A typical punctuation of a person's name by the insertion of colons or dashes before or after or among the first, middle, and last name, for example. So they give all these different ones, okay? Family lineage, which I was introduced to that over a decade ago. I used it for a little while, but abandoned it because I'd never seen any example of it having any relevance whatsoever. Family lineage, so anything with of the family, of the clan, of the house, right? Which is interesting because royals use the house. Why can't we? What's the legal distinction? But of the family and clan, sure, whatever. And there's lots of people who win in court without using these distinctions on their name, which is fine. Duplication and capitalization. Names of persons or parties are duplicated with one name in all capital letters and the other name in either lowercase and uppercase letters. Now, this is not capitalization on its own. This is duplication and capitalization together, which means that this format is forbidden. This format is forbidden. But John Doe in all lowercase or John Doe in upper and lowercase is not forbidden. It's just the combination. Doing both of them together is what's forbidden. Copyright or trademark. A person claims copyright or trademark in their name. This may be indicated by a sentence or adding copyright trademark symbols to the name. So a lot of people have been doing that. When I studied trademark and copyright years ago, there was an issue where anybody's name cannot be copyrighted or trademarked unless they have a public persona which is recognizable and commercialized. Like Madonna or Cher or Michael Jackson, that type of thing, right? Because they have commercial licensing rights that go along with the name, a recognizable name in commerce. So, these are all understandable. So I don't find anything wrong with what's been excluded here or included as a formal defect. I haven't suggested using any of them. I have used the house of fairly recently, but I stopped doing that. And that's the only one. Everything else I abandoned or never used. So, like I said, this doesn't affect me or what I've ever covered with private person or sue wrongdoers. And I think it's good news, largely. Okay. And like I said, it identifies exactly what the problem is, gives the court clerks specificity as to what they can't accept and why, and they have to actually give you a refusal in writing, which is all wonderful. Anybody have any comments or questions about this particular document? Speak up now or forever hold your peace, kind of thing. Anyone? I know some people, when they saw this, were kind of pissed off about who do they think they are and stuff like that. But like I said, it's generally speaking not a problem. And notice which court it's being issued from, the all capital one in the all capital Calgary, etc. And yeah, so generally speaking, not a problem, but I think it addresses an outstanding issue, reasonably well.